Okay. Well, I've learned a lot about lawyers today. I've never been one, but I have played one on stage. And I'm figuring nobody here that's left is concerned because we're getting paid by the hour, right? You, Mr. Morgan? Not everybody. Okay. All right. Ms. Pittman.
Thank you, Mr. Chairman. To wrap this hearing up, ORS would like to call its final panel of Willie Morgan, Michael Seaman Wynn, and Dr. John Roof.
I do.
Mr. Morgan, please state your full name and occupation for the Commission.
My name is Willie Morgan. I'm the Deputy Director for Utility Rates with the Office of Regulatory Staff.
Are you the same Willie Morgan who pre-filed 9 pages of direct testimony in this docket on February 26, 2019?
Yes, I am.
Do you have any changes, edits, or corrections to your pre-filed direct testimony?
No, I do not.
If I asked you today the same questions as those posed in your pre-filed direct testimony, would your answers be the same?
Yes, it would.
Does your direct testimony contain information deemed confidential by the company?
Yes.
At this time, Mr. Chairman, ORS asks that the public pre-filed direct testimony of Willie Morgan be read into the record as if given orally from the stand, and the confidential version be included under seal.
Mr. Morgan's public pre-filed testimony will be entered into the record as though given orally from the stand, and the confidential will be held under seal.
Thank you. Mr. Morgan, did you also file an exhibit as attachment WJM1 to your direct testimony?
That's confidential, exhibit WJM-1.
Do you have any changes or corrections to that exhibit?
No, I do not.
All right. And ORS would ask that we do have a public version of that exhibit that has been filed, if we can have that moved in, and then also the confidential WJM1 moved in under seal.
Okay, the public exhibit WJM1 will be exhibit number 57, and the confidential exhibit will be held under seal.
Does it get an exhibit number, or is it also just, it'll be 58?
58, sorry.
No problem. Mr. Morgan, did you also prepare 6 pages of surrebuttal testimony in this docket, which was filed with this commission on March 19th, 2019?
Yes, I did.
Do you have any changes, edits, or corrections to your pre-filed surrebuttal testimony?
No, I do not.
If I asked you today the same questions as those posed in your surrebuttal, would your answers be the same?
Yes, it would.
ORS requests that the pre-filed surrebuttal testimony of Mr. Morgan be read into the record as if given orally on the stand.
Mr. Morgan's pre-filed surrebuttal testimony will be entered into the record as though given orally from the stand.
Thank you. Mr. Morgan, did you prepare a summary of your direct and surrebuttal testimonies?
Yes, I did.
Please present that to the Commission at this time.
Thank you. Good afternoon, Mr. Chairman and other members of the Commission. The purpose of my testimony is to set forth the findings and recommendations resulting from ORS examination of the company's application and to address certain pro forma adjustments. My testimony will specifically address the following adjustments, and they are to amortize deferred cost balance related to the Carolina West Control Center, amortize deferred cost balance related to the W.S. Lee Combined Cycle Plant, adjust reserve for end-of-life nuclear costs, adjust for Lee nuclear amortization, amortize deferred cost balance related to SC AMI, and normalize for storm costs. For the request to amortize deferred cost balance related to the Carolina's West Control Center, ORS recommends an amortization period of 30 years, which is the service life of the Carolina West Control Center. ORS recommendation for the amortization period of the deferred balance is consistent with the service life of the asset. For the request to amortize deferred cost balance related to the W.S. Lee Combined Cycle Plant, ORS recommends the amortization of these costs over the remaining service life of the W.S. Lee Combined Cycle Plant, which is 39 years. It is reasonable to base the amortization period upon the life of an underlying asset because that is the period which is anticipated to benefit the customer. For the request to adjust reserve for end-of-life nuclear costs, ORS recommends the Commission deny the company's request of approximately $7 million for a reserve fund for its end-of-life nuclear costs. The reserve fund includes estimates for end-of-life nuclear fuel and parts inventory that are not currently known and measurable. The date of retirement of the nuclear units is uncertain. For the request by DEC to adjust for Lee nuclear amortization, ORS finds that DEC's decision to incur costs to obtain the combined operating license and support pre-construction activities were reasonable given the information available to DEC at the time the costs were incurred. However, ORS does offer a recommendation which adjusts DEC's request. ORS recommends the Commission disallow DEC's recovery of $129,433 related to the pre-construction costs for the Visitors Center associated with the Lee Nuclear Project. The Visitors Center is not constructed. The expenditures related to the Visitors Center were not necessary to support DEC's process to obtain a combined operating license from the Nuclear Regulatory Commission for the Lee Nuclear Project. Except for the costs related to the Visitors Center, ORS recommends the Commission approve the pre-construction costs of the Lee Nuclear Project, which total $124,601,000 without a return on the investment. The Lee Nuclear Project is neither used and useful nor providing electricity to DEC's customers. Therefore, the company's investment does not meet the criteria to be placed in plant in service. Thus, the investment does not belong in rate base and is not entitled to a return. Specifically, this Commission made a similar decision regarding the cancellation of other nuclear construction projects in order number 83-92 and docket number 1982-50-E concerning the Perkins Nuclear Station and the Cherokee Units 2 and 3. Customers should not have to pay a return on a council nuclear project when they will not receive a benefit. For the request to amortize deferred cost balance related to the SC AMI, ORS recommends the company be allowed to amortize these costs over 15 years, which is the service life of the AMI meters. For the company's request to normalize the storm costs, ORS recommends eliminating the expenses in the highest and lowest years and to use an 8-year average expense level. The company's adjustment adds an inflation adjustment to determine its 10-year average storm expense adjustment amount. ORS recommends the Commission reject the inflation adjustment as it shifts all risks away from the company and onto the customers. The inflation adjustment proposed by the company is not known and measurable. It is speculative and is based on generalized data for the economy. This concludes a summary of my direct and cerebral testimony. Thank you.
Mr. Morgan, can you clarify for me right quick? I want to make sure we got the right number here. What is the amount that ORS is recommending to disallow regarding the Visitor Center at the Lee Nuclear Project?
Okay, we're recommending a disallowance for the South Carolina portion of $129,443,000.
Great. Thank you so much. Mr. Seaman Wynn, please state your full name and occupation for the Commission.
My name is Michael Seaman Wynn. I am a Senior Regulatory Manager with the Office of Regulatory Staff.
Are you the same Michael Seaman Wynn who pre-filed 16 pages of direct testimony in this docket on February 26, 2019?
Yes, I am.
Do you have any changes, edits, or corrections to your pre-filed direct testimony?
Yes, I do. On page 13 of my direct testimony, line 20, the number 1.1% should be replaced with 1.0%. Additionally, on page 14, line 19, the number $61,794,822 should be replaced with negative $61,794,822.
Subject to these changes, if I asked you today the same questions as those posed in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
ORS asks that the pre-filed direct testimony of Michael Seaman Wynn be read into the record as if given orally from the stand.
Mr. Seaman Wynn's pre-filed direct corrected testimony will be entered into the record as though given orally from the stand.
Thank you. Mr. Seaman Wynn, did you file as an attachment to your direct testimony a series of exhibits marked as Exhibit MSH1 through Exhibit MSH5?
Yes, I did.
Do you have any changes, edits, or corrections to any of those exhibits?
Yes, I do. On Exhibit MSH4, the numbers in the right-hand column should all be negative and should read negative $0.004591, negative $0.002771, negative $0.001767, and negative $0.01119.
Thank you. ORS asks that exhibits MSH1 through MSH5 be marked for identification and entered into the record of this case as the next composite hearing exhibit with the changes that Mr. Seaman Wynn just provided.
Mr. Seaman Wynn's exhibits MSH 1 through 5 as corrected will be entered as hearing exhibit number 59.
Thank you. Mr. Seaman Wynn, did you also prepare and cause to be filed with the Commission on March 6, 2019, 4 pages of supplemental direct testimony?
Yes.
Do you have any edits or corrections to your supplemental direct testimony?
No, I do not.
If I asked you those same questions today, would your answers be the same?
Yes, they would.
Mr. Chairman, ORS asks that the pre-filed supplemental direct testimony of Michael Seaman Wynn be read into the record as if given orally from the stand.
Mr. Seaman Wynn's pre-filed supplemental direct testimony will be entered into the record as though given orally from the stand.
Thank you. And Mr. Seaman Wynn, did you also file exhibits marked as supplemental MSH1 through MSH3 and supplemental MSH5 along with your supplemental direct testimony?
Yes, I did.
Do you have any changes to any of your supplemental exhibits?
No, I do not.
Mr. Chairman, ORS asks that exhibits supplemental MSH1 through supplemental MSH3 and supplemental MSH5 be marked as the next composite hearing exhibit and entered into the record.
Okay, Mr. Seaman Wynn's exhibit supplemental MSH 1 through 3 and MSH 5 will be entered as hearing exhibit number 60.
Thank you. Mr. Seaman Wynn, did you also prepare 10 pages of surrebuttal testimony in this docket, which was filed on March 19th, 2019?
Yes, I did.
Do you have any changes, edits, or corrections to your surrebuttal testimony?
No, I do not.
So if I asked you those same questions today, your answers would be the same?
Yes, they would.
Mr. Chairman, ORS asks that the pre-filed surrebuttal testimony of Mr. Seaman Wynn be read into the record as if given orally from the stand.
Mr. Seaman Wynn's pre-filed surrebuttal testimony will be entered into the record as though given orally from the stand.
Thank you. And Mr. Seaman Wynn, did you also file a series of exhibits along with your surrebuttal testimony identified as surrebuttal exhibit MSH1 through surrebuttal exhibit MSH5?
Yes.
Do you have any edits or changes to those exhibits?
No, I do not.
Mr. Chairman, ORS asks that surrebuttal exhibits MSH1 through surrebuttal exhibit MSH5 be entered into the record as the next composite hearing exhibit.
Mr. Seaman Wynn's surrebuttal exhibits MSH 1 through 5 will be entered as hearing exhibit number 61.
Thank you. Mr. Seaman Wynn, did you prepare a summary of your direct, supplemental, and surrebuttal testimonies filed in this docket?
Yes.
Please present that to the Commission at this time.
Good afternoon, Mr. Chairman and members of the Commission. My testimony addresses OR's examination of Duke Energy Carolina's application. Specifically, I address the company's cost of service study, depreciation study, rate design, revenue verification, and revenue requirement distribution, the company's pro forma adjustments pertaining to the company's calculation of extra facilities charges, and ORS's customer growth calculation. The distribution of the additional revenue requirement and the proposed EDIT rider to customers, and the impact of the proposed rates on customers' bills. ORS analyzed the company's cost of service study and concluded, for the purposes of this application, that the methodology is reasonable. The methodology, provides a reasonable assessment and allocation of the company's revenues, operating expenses, and rate-based items. However, ORS recommends that the Commission disallow recovery of coal ash management and disposal expenses related to North Carolina laws and regulations above and beyond federal regulations. It is ORS's position that South Carolina customers be held harmless for the incremental cost differences attributed to North Carolina state laws. As part of the application, the company petitioned the Commission for an accounting order to adopt the new depreciation rates in its new depreciation study effective August 1st, 2018. ORS reviewed the study and has no objection to the company petitioning for an accounting order to adopt the revised depreciation rates. Based on ORS's adjustments, as addressed by ORS Witness Smith, and a 9.3% ROE as recommended by ORS Witness Purcell, ORS initially recommended the Commission approve a revenue increase to the company of $77,302,000, excluding the refund from the EDIT rider. This recommendation was updated in supplemental testimony and again in my rebuttal testimony. ORS's updated recommended revenue increase to the Commission for DEC is $82,357,000. The revenue increases for ORS's recommendation by customer class are reflected in my rebuttal exhibit MSH1. ORS recommends that the revenues generated by the billing determinants not exceed the target revenue for each class as proposed in rebuttal exhibit MSH1. Overall retail increase, including ORS's proposed adjustments and the EDIT rider, is 1.22%. My rebuttal exhibit MSH2 provides the resulting rate of return by customer class, taking into account ORS's proposed adjustments and excluding the EDIT rider. The overall rate of return for total retail is 5.75%. ORS recommends that any increase granted by the Commission be allocated in a manner such that the rates of return are as equitable as practical. The company has recommended changes to its existing tariff structures, including substantial increases to the basic facility charge for residential and small general service customers. The company's proposed increases do not follow the principle of gradualism in designing rates and tariffs. ORS recommends the Commission allow DEC to only increase the basic facility charges for residential and small general service customers to recover up to 25% of the approved revenue increase. Using this methodology and ORS's revenue recommendation, the increase to the BFC would be $11.96 per month for residential non-time of use customers, $13.09 a month for residential time of use customers, and $11.70 per month for small general service customers, as shown on rebuttal exhibit MSH3. Incorporating all ORS's adjustments and recommendations, the monthly bill for the typical residential customer on rate RS using 1,000 kilowatt hours would increase by approximately $4.46 or 3.8% from $117.74 to approximately $122.20.
Thank you. And Mr. Seaman, are you aware of a letter filed by the company on March 20th regarding the proposed basic facilities charges for residential and small general service customers?
Yes, I am.
And does that letter accurately reflect ORS's position regarding the calculation of the BFC?
No, it does not.
And could you explain?
The company is agreeing with the basic facility charge figures that I just read to the Commission. It is not ORS's recommendation that those be the basic facility charges for customers on residential, time of use, non-time of use, and small general service. It is ORS's recommendation that whatever revenue increase this Commission grants to the company, that 25% of the revenue allocated to small general service and to residential service go towards the BFC. We're not recommending specific BFCs in this case.
Great, thank you. Does that conclude your summary?
Yes, it does.
Thank you. Dr. Roof, will you please state your name and occupation for the Commission?
My name is John Roof. I'm the owner and principal of the Roof Group, which is a research and policy analysis firm.
Okay. Are you the same Dr. John Roof who pre-filed 5 pages of surrebuttal testimony in this docket on March 19th, 2019?
I am, yes.
Do you have any changes, edits, or corrections to your pre-filed surrebuttal testimony?
Yes, on page 4, line 12, where it refers to household income, I have the sign reversed on that, and rather than more than 30,000, it's less than 30,000.
Okay, thank you. So with that correction, if I asked you the same questions today as those presented in your surrebuttal testimony, would your answers be the same?
Yes.
And Mr. Chairman, if it pleases the Commission, Dr. Roof's testimony is brief, so I was going to read through his question and answer with him, and after that, there is a coordinating exhibit that I'll move into the record.
Okay.
All right. Dr. Roof, please summarize your educational background and professional experience.
I earned a PhD in history at the University of Illinois at Urbana-Champaign, awarded in 1976 to go with an MA from Illinois in 1971 and a BA from Seattle University in 1969. For 40 years, I have engaged in policy analysis and advocacy on energy and utility issues in South Carolina, including participating as a pro se intervener in rate and rulemaking proceedings before this commission from 1979 through 2002 regarding electricity, gas, telecommunications, and transit. From 1979 to 1987, I was employed by Fairfield United Action to organize and advocate around a broad set of community issues, including licensing of VC Summer Unit 1 and South Carolina Electric and Company gas rate increases. I represented consumer issues on a broad range of issues before the South Carolina General Assembly from 1987 to 2011 for South Carolina Fair Share, with a particular emphasis on low-income consumers. A significant portion of that work related to regulatory policy for electric and gas and telecommunications utilities. I continue to engage in legislative and stakeholder processes on behalf of AARP South Carolina and South Carolina Appellate Legal Justice Center. I have appeared numerous times as an expert in state and federal courts, testifying on statistical analyses, social and economic matters, demography, household economics, Southern history, Southern politics, elections, redistricting, and voting rights.
Have you previously testified before the Public Service Commission of South Carolina?
Yes, I have testified before this commission on public interest pay telephones in docket number 2003-358C. Most recently, I presented an allowable ex parte briefing to the commission in this docket on the effects of the proposed rate adjustment on consumers. I presented to the commission in 1997 as it prepared proposed electric restructuring implementation process report of February 3rd, 1998 to the General Assembly. My curriculum vitae is attached as surrebuttal exhibit JCR1.
And actually, Mr. Chairman, since he's just mentioned that, do you have any corrections to that
No.
exhibit, Dr. Roof? We can enter, if we could enter exhibit JCR1, have that marked for identification and entered as the next hearing exhibit.
Okay, Dr. Roof's exhibit JCR 1 will be entered as hearing exhibit number 62.
Thank you, Mr. Chairman. Dr. Roof, what is the purpose of your rebuttal testimony in this proceeding?
The South Carolina Office of Regulatory Staff requested that my rebuttal testimony address the impact to the customer if the positions outlined in the rebuttal testimony of Duke Energy's Carolinas DEC, or the company, were to be adopted by this commission. The company rebuttal testimony asserts it is entitled to cost recovery in excess of a level reasonable to support safe, reliable, and high-quality utility service. As DEC witnesses state in rebuttal testimony, the Commission's actions seek to reduce regulatory lag. However, the company proposes to shift the company's risk to its customers as a result.
In your opinion, what is the important role of the Commission in this rate proceeding?
From the Commission's perspective, a rate case is not just an exercise in deciding accounting adjustments, but about balancing interests between customers and the company and shareholders. For many years in South Carolina, ORS shared that responsibility, but in 2018, the General Assembly removed from the ORS responsibility for the financial viability of the company and economic development and job retention. That leaves the Commission to that important balancing act. Much of that balancing turns upon deciding who should bear the risks of those decisions.
Dr. Roof, please identify the areas in the company's rebuttal testimony that focuses on the shift of risk to customers.
Much of the rebuttal testimony submitted by the company focuses on issues that entail shifting risks from itself onto customers. For example, Company President Garte Tago's rebuttal testimony addresses financing deferred costs, disallowance of certain approaches to employee compensation, tripling the basic facilities charge, treatment of deferred balances, and return on equity.
Please explain the impact on customers when the risk is shifted from the company to the customer.
Let me focus on the basic facilities charge increase that has been the subject of contention both in direct and rebuttal testimony in this case and in the very heavily attended public hearings in the case. Witness Pirro largely portrays the increase as intended to reflect full cost recovery of the customer component identified in the unit cost study and to minimize subsidization of customers within the rate class. In other words, it's simply an intra-class shift from high users to low users. However, front-loading costs also shifts the revenue risks of lowered load growth, improved weatherization and efficiencies in heating and air conditioning and appliances, distributed generation expansion, and battery storage expansion from the company onto customers. Company witness Garte Tago suggests that this shift mostly reflects low-usage customers, such as customers with vacation and second homes. However, DEC witness Pirro presents clear evidence in his chart, number of DEC low-income bills by usage level for households income below $30,000, that most low-income customers, including low-income seniors and renters, are low-usage customers. All of the effort to minimize the share of low-income customers who are low-use customers is belied by simply looking at Pirro's chart. The majority falls below the 1,100 monthly kilowatt-hour average. The risk shift falls on all but the highest use customers, but most heavily on low-income customers, those who are least able to afford this increase and for whom the increase most threatens their ability to pay rent or mortgages and decent, safe, and affordable housing, ensure that their homes are not dark, cold, or hot, even life-threateningly so, buy sufficient, healthy food, afford and maintain reliable transportation, and pay for all needed prescriptions and health care. Even the alternate approach offered by company witness Pirro in response to the controversy around the basic facilities charge more than doubles that charge to $18.15. That mitigates, but far from eliminates, the harm to low-income customers. Here, the balancing of risks and of fairness calls on the Commissioner to lower the risk shifted to low usage, especially low-income customers.
Does this conclude your rebuttal testimony?
Yes, it does.
Thank you, Dr. Roof. Mr. Chairman, this panel is available from cross and questions from the commissioners.
Thank you. Company wants to go first.
As Mr. Ellaby explained during the last ORS panel, we prefer to go last. Thank you.
Hey, I was just checking myself. I couldn't remember exactly how we do. Okay, vote solar. Or, no, you go first. You go first. He's gone. Is Mr. Cully gone? Mr. Neal.
Thank you, Chairman Randall, commissioners. Good afternoon. I'm David Neal, representing South Carolina NAACP, Coastal Conservation League, and Upstate Forever. First, Mr. Seaman-Wynn, I appreciated your clarification that ORS's position is not that $11.96 is the recommended BFC. Did I understand that correctly?
That is correct.
Okay. It's just that if the allowed revenue that ORS is saying could be, if that was approved, the resulting BFC would be $11.96.
That is correct.
Okay. And you'd agree that that's a $3.67 increase over the current BFC of $8.29 for residential?
Yes.
And, you know, lawyer math is always dangerous, but that would mean, as I understood your summary, of a 1,000 kilowatt hour household under ORS's scenario, you said the average bill would go up from $117.74 to $122.40, which I believe you described as a 3.8% increase.
I believe I said $122.20.
Okay.
But yes, it would be a 3.8% increase.
And you would agree that that means that the overwhelming bulk of that increase would come from the BFC, isn't that right? So if the overall increase was $4.46, $3.67 of that is just from the BFC alone.
That math would be correct.
Thank you. One other thing, Mr. Seaman-Wynn. Is this thing? Do you recognize this as one of your supplemental exhibits?
Yes, this appears to be my supplemental exhibit MSH5.
And Mr. Seaman-Wynn, were you here earlier this afternoon when Duke Energy Carolina's witness, Ms. Smith, was testifying?
Yes, I was.
And do you recall, in response to commissioner questions, Ms. Smith talking about how Duke DEC's rates are lower than the national average?
Yes.
And if I could draw your attention to your exhibit that's up on the Elmo, you would agree, wouldn't you, that under DEC's the company proposed Schedule RS of $132.48, that would have put them above the South Atlantic 2017 average of $125. Isn't that right?
Yes, it would.
Thank you. Dr. Roof, good afternoon. Couple quick things. You referenced in your rebuttal a chart from DEC witness Perot. Is that right?
Yes.
Is this the chart you were referring to?
Yes.
Now, I want to make sure I understand this. Is it your understanding that on the left-hand side, on this axis, the y-axis, that's showing the number of bills that fall within the given range on the x-axis?
Yes.
And so...
That's the y-axis.
Thank you. And so, just to clear up something that came up in questioning of Mr. Perot, It's your understanding that under this chart, a household that uses 200 kilowatt hours, there's about 3,000 of those bills, right?
Thereabouts,
Somewhere between 2,000 and 4,000.
yes.
And then if you go up one to a household that uses 300 kilowatt hours, you see that there's, again, somewhere between 4 and 6,000.
Yes.
And if you go up one more to is the 400 kilowatt hour, you're up to 8,000 bills.
That's correct.
So we're talking about at least somewhere in the neighborhood of 16,000 households that use between 200 kilowatt hours a month and 400 kilowatt hours a month that are under $30,000.
Thereabouts. I didn't add that up in my head while we were doing
Okay. Now, finally, Dr. Roof, you mentioned also in your rebuttal that you presented a allowable ex parte briefing to the Commission on February 20th, 2019.
Yes,
On the effects of the proposed rate adjustment to consumers.
I did.
And that would be hearing number 19-11759.
Yes.
Instead of going through this, may I ask the Commission either to enter this as a hearing exhibit or take judicial notice? It's been put on the PSC's website.
We'll take judicial notice.
Thank you. And again, that would be for both the transcript and slides from Dr. Roof's presentation. Thank you very much. I have no further questions.
Thank you. Other cross.
Please, Chairman. I have some questions for Mr. Morgan. Mr. Morgan, I'd like to talk with you a little bit about the ORS position.
They can't hear you. I don't know if your mic's close enough to you or if it's turned up loud, or you're just going to have to talk louder.
Is this any? Yeah. I'm trying to avoid using this microphone. Mr. Morgan?
Okay, they said they're nodding.
I'd like to talk with you a little bit about the ORS position on the recovery of the nuclear abandonment cost. Would you help me with that, please?
I'll attempt.
Yes, sir. You'll be fine. Now, you're familiar with Mr. Fallon's testimony in this docket, are you not?
I looked at portions of his testimony.
Yes, sir. And you recall that Mr. Fallon gave a good history of the nuclear costs which Duke has incurred and for which it's seeking recovery in this docket. You recall that, don't you?
I recall reading portions of that. His
yes, sir.
position.
And you recall, either from his testimony or from your own analysis, that in 2008, Duke sought and obtained an order approving an application to incur nuclear generation pre-construction cost. You recall that, don't you?
I recall looking at some of that information.
Yes, sir. And I have the first page of that order, that June 9, 2008 order number 2008-417 on the Elmo. And does this appear to be the order of this commission in that docket?
It appears to be an order from the commission.
All right, sir. And you will note that the company brought its application pursuant to a code section 58-33-225. You will note that, will you not, sir?
I see that.
And do you understand, Mr. Morgan, that that provision is a part of what is called the Base Load Review Act?
The specific site, yes, sir.
Yes, sir. And under that provision, 58-33-225, Section B, the law states, and stated at the time, at any time before the filing of an application or a combined application under this act related to a specific plant, a utility may file a project development application with the Commission and the Office of Regulatory Staff.
Mr. Elliott, I don't think they can hear you.
It may help you turn that microphone on that podium off in addition to your loudspeaker.
Excellent. Thank you. Let's see, is this any better? So you see the language that I read in the in section 58-33-225, do you, Mr. Morgan?
Yes, sir.
All right, and under the Base Load Review Act, the company may obtain a project development order. And you will agree with me that a project development order means an order establishing that the prudence of a utility's decision to incur pre-construction costs associated with nuclear plant or potential nuclear plant. Do you see that?
Yes, sir.
And pursuant to 58-33-225, the Duke obtained such an order, as the order reads, Duke Energy Carolina's decision to incur Lee Nuclear Station pre-construction development costs as described in its application testimony and exhibits is reasonable and prudent. Do you see that language of order number 2008-417?
Yes, sir.
And in furtherance of the Commission's order, Duke Energy Carolinas was authorized to incur the South Carolina allocable share of $230 million in Lee Nuclear Station project development costs as described in its application testimony and exhibits through December 31, 2009. Do you see that order?
Mr. Chairman. Mr. Chairman, with all due respect, this order has been given judicial notice. It speaks for itself. This is a non-legal witness. It's not really clear what Mr. Scott is trying to do with this order, but read it out loud again at 5:30 in the afternoon. So I'd object to it being continually read now that it's been noticed, Mr. Chairman.
Okay, we're going to let this go a little longer.
Thank you, Mr. Chairman. I would concede that it's 5:30 in the afternoon. And so order number 2008-417 gave Duke authorization to incur up to $230 million through December 31, 2009. That's what the order says, correct?
That's my understanding, yes, sir.
And you are aware that Duke subsequently filed to amend its project development application. You're aware of that, are you not?
I'm aware of a subsequent filing, yes, sir.
All right. And so I show you the first page of order number 2011-454 and point to your attention the label Order Approving Amended Project Development Application and Settlement Agreement. Do you see that language?
Yes, sir.
And this order is dated July 1, 2011, correct?
Yes, sir.
And pursuant to the terms of order number 2011-454, the Commission ordered that the company must incur only those costs absolutely necessary to keep the Lee nuclear project available as an option in the 2021 timeframe. The prudency determination made in this proceeding applies only to the South Carolina allocable share of the additional pre-construction costs of $75 million without AFUDC, not to exceed $120 million with AFUDC for the period January 1, 2011 through June 30, 2012. Do you see the provisions of that order?
Yes, sir.
Now, you understand that Mr. Fallon, on behalf of the company, filed pre-filed testimony at page 32, lines 16 through 18, where he testified of the total $350 million authorized by the Commission through the 2008 and 2011 Lee Nuclear Project Development Orders. DE Carolinas incurred approximately $251 million during the authorized time periods of the orders. He testified to that, didn't he, sir?
I think that's what I recall.
Yes, sir. And you understand that, I think we all understand, that the South Carolina allocable portion of the $251 million incurred through June 30 of 2012 would be approximately $60 million, correct?
24%, I think.
Right. So thereabouts. I think he has the precise amount in his testimony, and I don't think it's disputed, but that can be calculated. So through June 30, 2012, the company expended $60 million in the South Carolina allocation towards its nuclear plants, correct?
That's, I believe, what it would work out to be.
Yes, sir. Now, you understand from Mr. Fallon's testimony, and I put here on the Elmo my copy of Mr. Fallon's summary, that the combined operating license for the Lee Nuclear Project was received at the end of 2016. You see that?
Yes, sir.
And in your analysis, are you able to confirm the date? Is that when they got the license?
That is what we've found to be the case, yes, sir.
Good, thank you. And you understand that Mr. Fallon testified at page 27 of his pre-filed direct testimony that the company incurred through September 30, 2018, $559 million in total costs. You understand that to be the case?
Accepting that it's on page 27, yes, sir.
What did I say, 29?
27.
27. It's on, beg your pardon, it is on page 27. And I understand from the testimony of the Duke witnesses that because of some of the real estate costs and the way that's accounted for, the total ask system-wide, company-wide, for inclusion in this rate case is about $518 million. Do you understand that to be the case?
I'm not sure the exact number, but I do understand the translation, what you're referring to as rates to the land.
All right. So, and you'll note from his testimony that the company is seeking to recover $248 million in AFUDC. You understand that to be the case,
Yes.
don't you? Now, Mr. Fallon testifies on page 26 of his pre-file direct that the company is seeking commission approval to recover the South Carolina retail allocable share of approximately $125 million of the total system spend, adjusted for non-depreciable land moved to the land held for future use. You understand that to be the case?
Yes, sir.
And with maybe the exception of, I think, that Welcome Center, visitor center to nowhere, y'all are close to the $125 million figure also.
Yes, sir.
Now, you also understand from Mr. Fallon's testimony, and I draw your attention to page 33 of his pre-file direct, that from July 1, 2012 through September 30, 2018, DE Carolinas incurred approximately $271 million, I think that's million, unless that's nuclear engineering math, million in additional Lee nuclear project development costs. You understand that to be his testimony?
Yes, sir.
And so understanding that the authorized amount of expenditure through June 30, 2012 is $251 million, Duke spent more than half of its total cost requested after the last authorized date by this commission of June 30, 2012. You understand that?
Yes, sir.
In fact, would it surprise you to learn that according to Duke witnesses, Duke Energy Carolinas had incurred $68 million in AFUDC as of June 30, 2012, the last date for which it was authorized by this commission to incur costs. Would it surprise you to learn that?
No, it would not surprise me.
And as a consequence, by virtue of Duke's delay in returning to this commission after June 30, 2012 for recovery of costs, the AFUDC alone ballooned from $68 million to $248 million. That would be the math, wouldn't it?
I understand that balloon
Yes, sir.
exponentially.
And so it is fair to say that while this commission has only authorized about $60 million in recovery under the Baseload Review Act, the company is seeking $125 million from their ratepayers at this time. Is that correct?
That's my understanding based on our review.
And I think I understand that Mr. Fallon's reasoning for that is that the General Assembly has amended the Baseload Review Act to preclude it from recovering its pre-construction costs under the Baseload Review Act. Is that your understanding of Mr. Fallon's testimony? And if it would help, for the record, I will refer you to page 25 of his testimony, lines 8 through 15, which I will publish. While I am not a lawyer, I've been advised that because DE Carolinas does not currently have any requests made pursuant to Article 4, Chapter 33, Title 58, pending before the Commission, it is unable to request recovery of the abandoned Lee nuclear project pre-construction costs pursuant to SC Code and Section 58-33-225G. Nevertheless, the company continues to comply with the requirements of the project development orders issued under the BLRA provisions by filing update reports pursuant to the terms of the settlement agreement. Do you see that language?
Yes, sir.
And so do you understand, as I do, that Mr. Fallon, on Duke's behalf, is advancing the proposition that because the Base Load Review Act precludes them from recovering any pre-construction costs, they cannot pursue pre-construction costs pursuant to the Base Load Review Act? Do you understand that to be his position?
Right, yes, sir.
And you understand that to be the company's position?
I would assume, I understand he's speaking on behalf of the company.
Yes, sir.
Yes,
Yes, sir. Now, Mr. Morgan, I would ask,
Mr. Chairman, I would just object to the extent that counsel's asked the witness to speculate on what the company's position is. He can say what he thinks the testimony says. He can't identify what the company's position is, and that would be my objection.
thank you, Mr. Chairman.
Sustained.
Yes, sir. Thank you. Now, you've been with the ORS for some number of years. In fact, I think you and I had our first case together back in 2004 or 5.
January of 2005.
Yes, sir. And I realize that I think you're relatively new in this current position, and you are doing an excellent job. But you would be aware, would you not, that beginning in about August of 2017, there began a considerable debate over the Base Load Review Act at the South Carolina General Assembly. You're aware of that?
Yes, sir. I've tried to avoid those 4-letter words.
Yes, sir. But I'm not going to let you. In fact, you would recall generally that on July 31 of 2017, South Carolina Electric and Gas and Santee Cooper both announced that they were abandoning the construction of the 2 nuclear plants in Jenkinsville, South Carolina, correct?
Yes, sir.
And you'll recall that on August 1 of 2017, SCE&G filed an application before this commission seeking recovery of about $4.7 billion under the Base Load Review Act under the abandonment provisions. You recall that?
Yes, sir.
And you understand that at the General Assembly, special committees were formed in the House and in the Senate to investigate the impact of the Base Load Review Act on abandonment costs. You understand that to be the case?
Yes, sir.
And you understand that the concern of the General Assembly was that that the ratepayers of the electric utilities not have to pay for any of these abandonment costs. You understand that to be the case?
Yes, sir.
And it was not a question of the General Assembly being upset that the ratepayers are paying too little. The concern was that ratepayers are going to pay too much. Isn't that the case?
They were going to end up having to pay for something that they weren't going to receive a benefit from.
All right. And against that backdrop, you understand that the General Assembly passed an act. It was House Bill H. 4375. With an effective date of 6/28/2018. You understand that, don't you?
Mr. Chairman, I would object. One, counsel's testifying. In addition, the relevance of this issue at this point in time, Commissioner, it's not been made clear through counsel's testimony.
Mr. Elliott, would like for you to move along on this.
I will do so.
I think your point's been in there a while.
Thank you, sir. And so, pursuant to that act, that act, we have the provision that Mr. Fallon testified to on page 25 of his direct testimony, where the General Assembly passed a law saying that Duke could not pursue these costs under the Base Load Review Act. Isn't that the case?
That's my understanding of it.
And as I understand it from your testimony, the ORS position is that these pre-construction costs of $518 million, $125 million to the South Carolina ratepayers, are not used and useful for utility purposes, correct?
That is correct.
And it would be perfectly reasonable for the General Assembly to pass a law saying, under the Base Load Review Act, if costs are not used and useful for utility purposes, the utility may not recover them. That would be reasonable for the General Assembly to do, would it not?
They could do that.
Yes, sir. Now, as I understand it, it's the ORS position that notwithstanding the fact that the Base Load Review Act has been amended to prevent the company from recovering these costs, that they may recover them in a rate case such as here. Is that your position, the ORS position?
I think that opportunity is available. At least they can attempt to, and it would be up to the commission to decide whether or not recovery is appropriate.
And in your testimony, you point back to a 1983 decision as precedent for that. Do you recall that?
Yes, sir.
And in that 1983 case, the company was authorized recovery of the abandonment costs for the Perkins plant and the Cherokee units 2 and 3, correct?
Yes, sir.
But as you testify, they were not entitled. The company at that time was not entitled to any recovery of those costs, correct? Any recovery of any return on those costs, correct?
Yes, sir.
Referring you back to order number 2008-417, I draw your attention to page 21 of that order. And do you recall from your analysis of this case that pursuant to the Base Load Review Act, the company was authorized to incur costs that would go to tearing down the prior Cherokee nuclear facility? Do you recall that? I draw your attention to the site preparation provision of that order, which I've highlighted.
I don't remember if I saw that particular section or not.
But as near as I can tell, the company in 1983 got to recover its abandonment cost of the Cherokee plant, and by a stroke of good fortune in 2008, pursuant to the Base Load Review Act, it was able to recover its cost of tearing that plant down. That would be correct, isn't it?
I think you're correct.
And the ratepayers would, in that case, get it going and coming, wouldn't they? Now, in 1983, was the Base Load Review Act was not in effect, correct?
That's my understanding, that it was something that was passed since 2000.
And let's say, would you subject check 2007?
I think that's around the time that I understand it was passed.
All right, and the company came in 2008 pursuant to the Base Load Review Act, correct?
I think that's correct, yes, sir.
Now, the company had available as an option to it in 2008 when it came in. It could have waited and asked to recover these costs in a general rate case, couldn't it?
Yes, sir.
And in fact, it had the option in 2008 to either file under the Base Load Review Act or it could file under a general rate case, correct?
Yes, sir.
But it elected to file under the Base Load Review Act, correct?
That's what I've learned that they did based on our review.
That's correct. And it was really a no-brainer for them because under the Base Load Review Act, they were entitled to get this early determination of the prudency of the decision to incur the nuclear cost, correct?
Yes, sir.
But under the general rate case, the company would have to incur, in this case, $559 million, and then come into this commission and ask for approval of the decision to incur those costs, correct?
Correct, a little different.
And so it made perfect sense for the company to elect to file under the Base Load Review Act, correct?
Yes, sir.
And as I understand the company position, it finds itself in the delightful circumstance of appearing before this court, this commission, to ask for recovery of an amount of $125 million, when if the Base Load Review Act had been in effect, it would have only been entitled to $60 million according to the commission orders, correct?
According to...
Mr. Chairman, I object. That calls for a legal conclusion, and the witness is not a legal witness. This is several times Mr. Elliott's already done this sort of legal conclusion cross.
Sustain. Let's get to the point, Mr. Elliott.
Yes, sir. So it's the company's position, and it's the ORS position that the company's entitled to at least $125 million.
You're asking me?
Isn't that true?
That's my understanding, what the company is requesting, and ORS does not object to that.
And that's the ORS position, notwithstanding the fact that the company did not come in pursuant to the Base Load Review Act for a subsequent amendment of its pre-construction order seeking recovery of this $559 million, correct?
Yes, sir.
And we learned that the company came in 2013 for a rate case, and it did not come in 2013 in its rate case to seek to recover the $559 million in its 2013 rate case. Isn't that correct?
I did not see it in my review of the 2013 case.
And so as I understand it, it's the ORS's position and the company position that the company should be rewarded because the Base Load Review Act was repealed.
Can you repeat that one?
As I understand it, it's the company position and the ORS position that Duke Energy Carolina should be rewarded because the Base Load Review Act was repealed.
I don't know if I would call it a reward, but ORS does not object to the request that's being made.
You would not be surprised if the company's customers thought it to be a reward, would you?
They could form that opinion, but I do believe that, the ultimate decision will be up to the commission here.
We agree on that. Thank you, Mr. Chairman.
Thank you.
Thank you. Other cross. Other parties. Company.
We don't have any cross-examination. That would be Mr. Marzo doing that. I'm getting up to put on the record our objection to judicial notice of the ex parte briefing that was requested earlier, the ex parte briefing that Dr. Roof gave. And this is just to put it on the record. I know y'all have already done it, but we don't think that an ex parte briefing, which is not given under oath, not subject to cross-examination, no pre-filing, and is the opinions of a person, a briefing to the commission. That's not the kind of thing that a court could take judicial notice of or that this commission should take judicial notice of. So to the extent the commission might end up or be asked to rely on that in a proposed order or in a brief or something, we wanted to make sure y'all knew the company's position on that point. I'm not asking for any ruling. I just wanted to put that on the record.
We'll note your objection
I didn't
for the record.
want to incite any further discussion.
Well, and I appreciate that, Mr. Ellerby, but just so it's clear, did that in part in the interest of time. I could have gone through those questions and asked Dr. Roof if he's still under here in open the commission, if he still has those positions. So, and you would then be allowed to cross on that as well. So I feel like if you would like to cross Dr. Roof on any of the positions in that ex parte briefing, you're able to do so.
Okay, we've noted the objections. Okay. We're not doing any cross? Okay, commissioners. Okay, thank you. Oh, were you? Commissioner Whitfield.
This panel. Yes, I have one or two.
One or two.
One or two.
Okay.
And it looks like they're going to go to you, Mr. Morgan. Mr. Morgan, on page 9 of your direct testimony, give you a second if you need to.
We're there.
Yes, okay. What is the basis for the recommendation on page 9 of your direct testimony that DE Carolinas eliminate the expenses in the highest and lowest years of storm costs and to use an 8-year average expense level?
Yes, sir. The reason for that is, as you're trying to compute an average for a set of numbers, and given the quantity of numbers we're talking about, 10 sets of numbers over the course of 10 years, you could conceivably have some anomalies on the low end and on the high end. So the attempt was to try to normalize the storm costs, and we felt that was the best way to do that. And that has some history behind it. As I've reviewed cases and also questioned others in the office, that's how it's been done in prior cases as well.
Okay. Thank you, Mr. Morgan. Last question, and it can go to you or to Mr. Seaman Wynn. And it's going to kind of be I hope your attorney doesn't jump up on this one, Mr. Nelson. But in the exchange you just had, or Mr. Elliott just had with the panel here, he talks about the ability of the company to come in under the BLRA or under a general rate case, which you talked about not seeing it, of course, in the 2013 general rate case. But he also talked about the increase in AFUDC during that time period, not electing to come in under a general rate case. And therefore, I guess what I'm going to ask you for an opinion. Do you think, either one of you, do you think it was prudent for the company to not pursue it way back then and to wait, since the Baseload Review Act was the law of the land at that time? Can you comment on the prudency of the company not coming in then and waiting till now? Because you said ORS supports it. You said ORS, when Mr. Elliott was crossing, you said ORS supports it. I guess I'm asking you, I guess I'm almost implying that you think it's prudent, but could either one of you address that?
I guess, I don't know if Mr. Seaman Wynn here would want to go first, but I wouldn't necessarily say I would support that effort. I mean, from my understanding, there were opportunities where the company could have came in under the Baseload Review Act, similarly as what SC&G did, and help mitigate the situation, what we're facing today. And there were opportunities.
I would concur with Witness Morgan. I would also say that the company's last rate case was in 2013. The BLRA underwent adjustments. I suppose you could say it was done away with by the General Assembly in subsequent to that. Now, between the years of since the company's last rate case and prior to the BLRA going by the wayside, could the company have come in for a general rate proceeding during that time period to seek recovery of the costs underneath the BLRA? Yes, they could have. I understand from witness Fallon's testimony and in other witness testimony, the company was continuing to review the prudency of building the W.S. Lee nuclear station while we were seeing declining natural gas prices, and the company elected not to pursue the building of the plant during that time period, and decided not to pursue coming in underneath statutes of the BLRA before this commission for additional project development orders or any type of pre-construction costs. Excuse me, any type of construction costs.
Well, we got a situation to deal with. Unless either one of you have anything to add to that, I thank you for your answers. That's all I have, Mr. Chair.
Thank you. Commissioner Irvin.
So as I understand it, after going through the process of reviewing the orders and the sequence of events, ORS is changing their position now on the recovery of these costs. Is that right? You're saying that you're changing your position?
No, sir.
As far as recovery?
We're not changing our position. I thought the question was whether or not we felt it was prudent.
Well, that's kind of the key, though, isn't it? If it's imprudent, then it's not recoverable.
We thought the cost is reasonable given what they went through to get to this point of applying for recovery. Having gone through the extended period to obtain the license and achieving that.
But I guess the question that my fellow Commissioner Whitfield had was it prudent to wait that long? Because they could have asked for it earlier. They could have asked for it in 2013, correct? You acknowledge that?
Yeah, that part I don't know in terms of the prudency piece.
Okay, thank you.
Thank you.
Thank you. Other commissioners? Okay, Ms. Pittman, redirect.
Just briefly, just wanted to clarify something. It's ORS's position that the company can't come in under the BLRA. So they came in under Chapter 27, I almost said 28, sorry, 27, and we're not challenging the prudency of their decisions.
Okay, thank you, Mr. Ellerby.
Mr. Chairman, there's one other thing, and this is something else that we'll put in our proposed order or brief. Under the provisions of the BLRA that have now been repealed, the company could not have come in and asked for recovery of pre-construction costs under the provision it sought those until a decision was made to abandon the project. So that's what that statutory provision applied. So we switched from one regime and going back to the other one, as Mr. Morgan explained. Thank you.
Thank you. Okay. All right. I think, Commissioner Irvin, you've got something else.
Before we close the record, I've got one brief request for Ms. Smith. Is this an appropriate time? Are we through with this panel? I don't want to interrupt anyone else's cross. Go for it. All right. Thank you. All right. Ms. Smith, in addition to the item that we discussed earlier on the coal ash legal fees, there are two others that I'd like to request in the late filing. One stated May the 1st of 2017, and that charged for $228,750. And there's a third one that's May the 3rd of 2017 for $250,622.73. So for a total of three of those invoices, we'd like we'd like to have a late file exhibit that shows the detailed information concerning the matter, the relationship to. We need all the information that's available on those three, if you don't mind.
Including the matter description, correct?
Matter description,
Yes, sir.
so that we can make a determination as to whether or not it's related to the coal ash request for reimbursement.
Yes, sir.
Thank you.
And we'll put all of those together as composite number 56, where with the original request.
Yes, sir.
That works. Okay. All right. I think we've been through presentation. We've done cross. No redirect anymore. So I think the next thing to do then is get Mr. Dong to talk about proposed orders. Okay, I'll ask if anybody has any closing statement, except Scott.
My witnesses be excused.
I'm sorry. I always forget about you guys in the front. Thank you for your testimony. You may be excused. Now, does anyone have a closing statement? Okay, Mr. Dong.
I believe that there have been discussions off and on between the legal staff here and the parties about having proposed orders by the 17th of April, if that's acceptable.
Mr. Dong and Mr. Chairman, just for the record, quite frankly, that trying to get 5 proposed orders out of my small office in a couple of weeks is going to be extremely difficult. I would ask that we be permitted to file a post-trial brief as opposed to a detailed proposed order. We put a lot of hours into doing a proposed order, and quite frankly, we'd prefer just to brief the legal issues as opposed to writing the full order.
However you choose to do it, Mr. Nelson.
That wouldn't preclude us from being able to do a proposed order, correct?
It would not.
Okay, thank you. And just for the record, there have been a number of legal issues raised, and so we are contemplating, and it would be likely that we would have a proposed order and a supporting brief on some of the legal issues that have arisen in this proceeding.
That would be helpful. Thank you.
Ms. Grumman, get to a microphone.
So as we talk about the 17th, I guess I understand there's a statutory deadline that is somewhat pushing this particular issue. The only concern I have is that as I look at this hearing at approximately 6:15 on the Wednesday after the hearing began, we would be proposing that this be filed on the Wednesday after what I believe to be the scheduling for the DEP case. And so I'm just a little bit concerned about how I would be in 2 places at once.
We're concerned about that as well.
Yeah, you're not the only one.
But even if we moved it like the following day, where if we were to go 5 days again in DEP, even if we did the 18th, it would give parties an expectation of 1 full business day where they wouldn't be doing work for both.
Is that okay? Well,
and so then the 19th, I'm not sure that the commission is open. It's Good Friday. So as I just was looking.
Well.
So I'm just throwing out that even 1 additional day from my perspective would be very.
Sure. I understand. That's okay with me. I think I've got the authority to speak for the legal staff tonight since I'm the only one left here. So, and in fact, the office will be open Good Friday. But we're just. I think the problem that we're all running into is that we're under the gun for the order deadline for both the Progress case and Duke Carolinas, and we have a sewer case also due the same day. So we're trying to work around those statutory deadlines as best we can.
mean, obviously, if the 17th is the 17th, I'll make it work. As I looked at it, I just.
I'm obviously sympathetic, So, let's do this. Let's try to say close of business on the 18th.
Thank you.
Sure. Does anyone care whether I read through the exhibit list? No? Okay. Thank you.
You didn't ask me. I would care. Okay. And right, we can scan it if anybody needs to look through that. Okay. Do we have anything else that needs to come before us in this matter? I want to thank everyone for your work and your cooperation, and you did miss traffic again today, second day in a row, so we are adjourned.
Thank you all for making my job easier.